Do I really need an estate plan? Hi, I'm Scott Frank, founder of Stone Steps Financial, certified financial planner. Today, we're going to look at what is an estate plan and do I really need one? In the great state of California, if you own a home, I am going to say that yes, you probably need an estate plan just from the standard of probate costs. So in the state of California, and different states are different, so you can see whether or not you have probate costs in your own state. But around here, the first $1 million of an estate has probate charges of around $23,000. And it goes up from there, right? So one thing that you can look at is, wow, like who's going to pay for that? Well, the estate's going to pay for that, and it's going to have to go through this thing called probate court. Now, what's probate court? Probate court is basically a place where if you pass away and you don't have a plan for how you want your assets to be passed to someone else, you have to go to this place called probate court. And probate court has a long line in the state of California, so it can take a while to get everything handled. There's high costs, as I already mentioned, and also it's public information, so everyone's going to know about your business. So there's a lot of reasons why you might not want to go there. Now, the cool thing is there's a really simple solution: create an estate plan. So what does creating an estate plan actually mean? Well, creating an estate plan means you get a few key documents in place to help say how you want things to be handled for you and your family now and in the future. So we're just going to briefly walk through what those things are coming up. You can look to get one made, an estate plan made, by reaching out to an estate planning attorney. There's also some online software solutions that can help do this for you too. Another thing you can do is you can actually see if you can turn on a legal benefit through work that has estate planning attached to it. So those are 3 ways you could potentially go about trying to find someone to help you with an estate plan. The main documents in an estate plan that we help clients with here is the first one's called a living revocable trust. Now, living means you're alive, the people who created it. Revocable means that you're allowed to change it. And trust is just simply the entity, the legal entity that it is. It's not something separate. You don't have to start having new tax returns filed because you have a legal revocable trust. It basically is just going to flow through for you and your spouse if you guys create it. And what it does is it basically gives you some rules that you get to write about how do you want your assets to be passed. One of the biggest things that we're seeing right now is people are writing it, especially when they have young kids, to say, hey, I want my kids to receive assets, but I don't know that I trust them to receive all of the assets when they just turn the age of majority. So in the state of California, that's age 18. So like one of the questions I always have for clients is, you go look at maybe your net worth and what you have. Maybe you have some life insurance. And so let's just say you have a net worth of like $2 million and maybe you're 40 and you have a 8-year-old kid. Well, if those assets double by the time they're 18, now instead of $2 million, they're going to have $4 million. And the question is, would you trust yourself with $4 million when you turn 18? And most people are like, no, absolutely not. I would not trust myself. And so what you do is you write into the trust rules that say things like, hey, we're going to let this trust support our kids while they're growing up through an acronym called HEMS, which is Health, Education, Medical, and Standard of Living. And basically, we're going to let them be okay, but then we're not going to let them have access to the money in the trust until they reach specific ages. And so you might say something like, hey, at age 25, they get a third of it. And then at age 30, they can have half of what remains. And then at 35, they can have the rest of it. And that kind of protects them from making silly decisions along the way, right? So that's one reason why you could create a trust. There's lots of others, but a trust is really, really helpful. And the main thing that you're going to put in trust is going to be things like your home and taxable accounts, right? So like retirement accounts, you're probably going to name beneficiaries to retirement accounts on those. You're probably not going to name the trust. You might name the trust if it's for the kids, but that's something you can work out with the estate planning attorney, or an advisor might be able to help you with that too. From there, the other documents that you're going to create, each person's going to have 3 documents. You're going to have what's called a power of attorney, a healthcare directive, and a pour-over will. And what are those things? A power of attorney basically says like, hey, Scott got hit on the head and he can't really function right now. He's still alive, but he can't make his own financial choices. Someone needs to help him right now. So I've appointed my wife, and then there's other people that we've named thereafter to help make choices for me if I can't make them for myself. That's what essentially a power of attorney does. There's a little more nuance to it, but that's perfect for this. You each get to have those, right? And then a healthcare directive is similar, but what that's doing is that's saying the same thing, but it's only for medical choices. And what it's doing is you might within that also say things like, how would you like to be handled in specific circumstances? So, if you're going to be in a coma for a long time, how would you like to handle that? Would you like to be an organ donor? How would you like to, end of life to be handled for you? So you can put that in written word, which is really helpful so that when people are in an emotional time of distress, they don't have to make those decisions for you. You've already made them for yourself. And then the final document that you create is called a pour-over will. Now, pour-over will basically means whoops. So a pour-over will says, hey, you know what? We bought our house and we put it in the trust, and that was all great. But then, we bought it when the interest rates were higher and interest rates went down, and we refinanced our house, but we refinanced it into our own names, not into the trust. So now we have this asset that should be in the trust, but it's not. And so what we do there is the pour-over will basically allows us to have, you have to go to probate court, but it's essentially a paper processing of probate, where you go and you say, hey, judge, Scott meant to have this asset in trust. Here's his pour-over will. Anything that's his at his death is supposed to get poured into the trust. We just need to make that happen. So it's procedural. So those are the big documents that you have. And the reason that you have them is so that you don't have to deal with probate court. You don't have to deal with other people. You just get to deal with your family and the institutions that you guys are working with. And it makes a much more streamlined and simplified process when one family member passes, which is, really helpful when it's a time of distress. I hope that's helpful for an overview for you of what an estate plan is. If you don't have one in place and you have kids and you own real property, please look into getting one. It's so helpful to have. And I really hope that you found this to be helpful.